Tonight's meeting is, or lecture is regards to student expression, and so this will not be that long. I apologize for coming in a little bit late. I had a meeting in Charlotte I had to go to, and oh, Emily, I can see you can't hear me. Carl, you heard me, right?
Yeah.
Carl, can you hear me?
I can hear you just fine.
Okay, great. All right.
I don't know what's wrong with my sound.
Emily, I hear you, Emily.
I can't hear them at all.
Okay, well, I'm going to go ahead and begin.
I wish I could hear you.
Hold on, Emily, I'll just tell you something here. There you go. You can watch it afterwards, Emily, if you have to get down. So tonight's about student expression. I'm going to go ahead and give you a screen share here. All right, let's go here. Okay, so what we're talking about mostly here is freedom of speech, and with regards to student freedom of speech, that goes anywhere from what students say to what they wear, the clothing they wear, and this is, students don't lose their rights at the schoolhouse gate, is what is well known. But some of the things we're going to talk about here is that there are some limitations to speech, and so there is the freedom of speech, but there are things that we can say students can't do this or students can't wear this. Okay, speech that can be banned or regulated. First Amendment does not protect the following types of speech. It doesn't obscenity, which is a Bethel case we'll talk about in just a minute. Libel, defamation. And libel versus slander. Libel is written, slander is verbal. Fighting words, truth threats, as in the case of Jones versus State, and speech that advocates imminent lawless action. Courts have permitted reasonable regulation at the time and place. Restrictions are permissible as follows: not used to regulate content of speech, serves a significant government interest and narrowly tailored to serve the interest, allows ample alternative channels of communication. The form is analysis discussed previously, and the form, there's several types of form. You have open forum, you have limited public forum. Open forum is basically the right to go out into a park, go out into anywhere in the United States and be able to speak your mind about something here. Limited public forums are schools have limited public forums. In other words, we have some limitations that we can put on with regards to the speech there. The major case is Tinker versus Des Moines, Iowa. I'm sure you've probably heard of this particular case. It goes back to a student protest of the Vietnam War, and they wore armbands. And basically, it's the same expression that I used earlier, which is that this freedom of speech is not lost at the schoolhouse gates. That they still have their right. It had nothing to do with the school. It had nothing. There was no material substantial disruption to the school. That's really what the courts are looking for. Does that provide you can limit it if it provides a material substantial disruption to your school. In Tinker, there it is, substantial disruption or material interference with school activities. Reasonable forecast of substantial disruption of material interference is known as a Tinker standard. So anytime that decisions you have to be careful anytime you have decisions that affect whether you limit somebody's speech, whether it's clothing, whether it's what they're saying, and it has to meet the Tinker standard, which means it has to be something that could be materially and substantially disruptive to the school environment. On the other side of things is the Bethel case. The Bethel case is a situation where there was a speech given for school elections, and the person giving the speech used lewd vulgarity in their speech, and he was suspended. And basically, it ruled. This is a case that kind of strengthened the fact that schools could limit the speech. So that's Bethel versus Frazier. The other case we talked about a little bit last week, which is the Hazelwood case. The Hazelwood case limits speech. This is newspaper speech. A principal in this particular situation pulled out, I think it was two or three pages in an article. Was related to teen pregnancy and divorce, and the principal felt like that students would be able to be identified in those 2 pages, and he pulled it out, and the school district won that case. So that, again, that's censorship, but it was to avoid a substantial and material disruption. More information about this, and I'll send everybody the slides that come in this particular PowerPoint. Student dress, North Carolina. Now, remember last week we talked about there are federal laws and state laws, and this is a North Carolina General Statute 115C. 115C is the anything dealing with education. Okay, it's -391A. It was amended in 2001 to require local schools to include a reasonable dress code in their codes of conduct. So everybody should have a dress code generally in their discipline handbook. Supreme Court concluded that not all clothing is speech. The court requires this that considered speech. These things must take place. You have to have an intent to convey a message, a likelihood that the message will be understood, and the circumstances with which it's made. The courts have said we cannot accept the view that apparently limitless variety of conduct can be labeled speech whenever the person engaging in the conduct intends thereby to express an idea. Although the idea of the clothing does not express an opinion, it may not be protected by the First Amendment rights. A student's right to dress, to choose how they dress, may receive the same protection as the liberty interest in the 14th Amendment. Talks about dress code challenges, things like buttons, T-shirts. People, talks about kids wanting to show their individuality. But you can limit that, again, if it creates a material substantial disruption. The Tinker standard, okay, or the Frazier standard, which is the lewd, vulgar, and obscene gestures. You also have, in the last 10 years, significant changes in dress code violation or dress code to avoid having gang symbols, gang colors, those types of things. You have uniforms at some schools, a lot, certain elementary schools or middle schools. And there's a case down here, is a North Carolina case, Copper versus Dillinger. And here's a couple other cases that are discussed with regards to student uniforms in 1993. Since that time, school uniform policies have been adopted. Talked about that. Mandatory policies typically contain provisions allowing the students to opt out of the policy under certain situations, like religious and health reasons, in which it would create other discriminatory issues. Okay, and then we've got the religious objections here. Halifax County versus Board of Education. Great grandmother of a third grade student. Religious grounds based on the fact that she believed that wearing a uniform demonstrated allegiance to an antichrist, and so that was it ruled in her favor. They did rule against her favor, dismissed the claim that the policies exceed the scope of the district's authority. However, the court refused to dismiss the claim that the policy violated her right free exercise of religion. Here's another case. It's out there. I'll have this for you to look at. And that's it. That's it for student expression. And so I'm going to get out of this. I think everybody can see me now. So are there any questions that I see from anybody regarding student expression? It's not a lot. There's a lot to it, but it's pretty, I think, clear cut. It's you know, but it doesn't get clear cut when you start to see students wearing things that you think might be unacceptable. You have to make good judgment calls. Now, the one thing I would recommend is that in policies and handbooks that they're voted on by site-based team, it's really community standards that you're looking at. What is acceptable by a community or not acceptable by a community, and then clearly get those articulated in your policies and your handbook and those types of things. And then beyond that, questions to your own local attorneys. Your principals can request counsel to get feedback on certain things. And I find that schools make mistakes all the time. Schools, something goes into a handbook or some decisions made that it's a mistake. That we just have to work through those things. The law is the law. The law doesn't change, but lots of times interpretation is up for debate. So with that, that really kind of concludes tonight. It's a short night. Any questions from anybody? I do want to say one thing regarding evidence 3. I think everybody's been turning that in, or is working on turning that in. The visual, I've gotten lots of questions about the visual, and I would just like to say the visual is a needs assessment. You complete a needs assessment for what your stakeholder input or stakeholder strategies are to get stakeholders in your school to do certain things. And so it's a needs assessment that you just have to put in a visual form. And whether it's a PowerPoint presentation, some kind of visual chart. It's just if you had to present something to your staff and to talk about what are needs, what are human resource needs. Do we need to hire teachers to do certain, or hire people to do certain things, or do we? What are the other financial costs that it requires to meet the strategies that you plan on doing to get those stakeholders involved? Okay. If there are no questions for me, I'm going to end the broadcast, and thank you for coming tonight. I'll be here on Wednesday night to answer any questions that might be there about student expression or anything with regards to the next module's evidence that needs to be turned in. Have a great night. Thank you.